I had a bit of a disturbing revelation just before I started this recording, and we're going to get to that in a minute. But before we do, I want to clarify something, and that is, I listen to the feedback that I get from people who've read the book and watched these videos, and it seems that I didn't make myself clear on part of the fraud issue from the previous chapter. Everybody understands that the imputed, or just made up out of thin air, salary was fraud. They get that. That alone voids the divorce. What seems to be not fully understood is that because of a contempt order that does not exist, all of my responses and submissions to the court were thrown in the trash. The truth was trashed. Why? In addition, my lawyer was not allowed to represent me in court at the time of the divorce. He was not allowed to speak, despite the fact that he was standing right there. Not allowing me to be represented in court by my own submissions and represented by a well-known divorce lawyer is a wild violation of my civil rights. Both lawyers should have protested this. It is their duty as officers of the court to do so. Where do I get that idea? I was watching a similar case in which I was not involved. When the judge called the case, one litigant was not there. The judge said, "I'm going to close the case because of default." The opposing lawyer said, "Your Honor, the litigant has confirmed that he is on the way. In the interest of justice, I ask that the hearing of this case be postponed 1 hour. The judge agreed. Later, the case was called, and the good lawyer, I'm proud to call him that, was able to bring the case to a proper conclusion. In the hall, I confronted the lawyer and asked why he didn't just allow the case to be dismissed. His client would have simply won. He told me that as an officer of the court, it was his job to do everything possible to see justice served. There are good lawyers. My court's file on my case does not contain a contempt order. In fact, it can't. Since the court file does not contain an order of deposition or an order to attend one, there can be no basis for an order of contempt. Contempt of what? Some combination of a judge, 2 lawyers, and a defendant conspired to commit multiple layers of serious fraud here. Divorce court is civil court. My civil rights were denied. This practice is standard in courts such as this. You get it? Do I need 1,000,000 men and a smattering of women to tell you a similar story? No, because you already know, don't you? Now, I'm going to read chapter 16, which is called Default. I'm very proud of this chapter. And the revelation is that, well, I'll start and then I'll go out for a moment and come right back in. But chapter 16, Default. Thinking that she was my ex-wife, Stacy called me immediately after the divorce order was finalized to gloat. Now, when I wrote that sentence, I was uncomfortable, and I didn't know why. And I've proofread the book many times and gone through it, but thinking about it right now, Stacy never gloated ever. It was not her nature. She's not the kind who gloats. Remember, she's a silent treatment type. So the fact that she did call and gloat, because she did, something more is there. This is no time to speculate on what it is, and frankly, I can't. Maybe it'll come to me in another revelation later, but you gloat when you have something invested, or when you get away with something, or when, like, if you're sneaky and you get away anyway, then you gloat about it. You don't gloat if there's a pragmatic thing that happens and it's just factual and you just tell them the facts and you know, there's a good side and a bad side or whatever. But gloating is like it's personal. And it was real weird that she did that. I don't know if it was her voice or her lawyer's voice, or I don't know exactly what happened there, but back to the story, and back to the story. Thinking that she was my ex-wife, Stacy called me immediately after the divorce order was finalized to gloat. She told me, and this is practically a quote, "You should have seen how impotent your lawyer was, standing there while the enraged judge told him, 'You are not allowed to represent your client. He is not here. He is in default. He has no right to representation for that reason.'" That's what she told me. Enraged judge? Why? No right to representation? Why? Default? I sent my lawyer. The judge was wrong. It would seem to me that default is a big issue. It is commonly accepted that if there is no response to a motion in court, if lawful, that motion is granted. I proved fraud upon the court, which nullified my divorce order. I made a legal motion proving this and requested remedy through the court. I legally served multiple motions regarding this to my wife. Not only did she default every time, her lawyer of record sent multiple letters to me and the court stating that she, the lawyer, wanted no part of the proceedings. And I included the letter right in the book here. "Dear Sir, Madam, I am in receipt of this date of a post-judgment motion filed by John Fred Satilli, plaintiff pro se, returnable May 20th, 2011. I previously advised Mr. Satilli that my office does not represent Ms. Satilli. I represented her in her divorce proceedings in 1999, but have not represented her with reference to any post-judgment applications. I do not know where Ms. Satilli presently resides. I have not had any contact with her for more than a decade. I am again advising Mr. Satilli through this correspondence to direct all further communications to Ms. Satilli directly or to her counsel if she has retained counsel. Thank you very much for your courtesies, Lori Bernstein." Okay. Here we go for the list. What was the response from Stacy to my motions and the letters to her from the court also, regarding the court action? Motion, January 27, 2010. Stacy, default. Prayer for default judgment, April 26, 2010. Stacy, default. Motion for reconsideration, June 24th, 2010. Default. Remember, Stacy's getting a copy of every one of these things from the court, so it's not as if she's not opening my mail. She's also getting this information from the court itself, and I don't think anybody would not open up a letter from the court. So this default is knowing. Bernstein, letter of non-involvement, July 2nd, 2010. Notice of fraud by court clerks, July 26th. Motion for default reconsideration, August 6th. Stacy, default. Acknowledgement of court clerk error, February 9th, 2011. Stacy, default. Fraud motion to vacate, April 15th, 2011. Stacy, default. Bernstein again, letter of non-involvement, April 23rd, 2011. Notice of default, May 18th, 2011. Stacy, default. Judge Troiano acknowledges default May 19th, 2011. Stacy, default. Notice for reconsideration September 29th, 2011. Stacy, default. In the years 2010 and 2011, Stacy defaulted on court action, but was favored by the court each time. Why? During this 2-year period, when I reopened our case with my knowledge of fraud upon the court, there was much more activity than the brief summary above. The incredible fact is that the judge, James Troiano, committed default himself. New Jersey has very clear laws as to judicial behavior. Judge Troiano violated that law. But who judges the judges? August 4th, 2011. This is a letter to the Advisory Committee on Judicial Conduct, the ACJC. This goes to the Hughes Justice Complex on Market Street in Trenton, New Jersey, regarding Judge James G. Troiano's refusal to issue rulings. Dear Advisory Committee on Judicial Conduct, a motion in case number blah 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 was properly filed by the plaintiff in the above referenced matter with the Superior Court of Essex County and served upon defendant on February 2, 2010. The defendant defaulted by failing to file any responsive pleading, and defendant's attorney of record sent letters to me in the court stating that she was no longer employed by the defendant. Judge Troiano ruled against the motion June 1, 2010, based upon a misunderstanding in regard to R450-1. The ruling was not sent to me until I received a fax on June 8, 2010. 16 calendar days later, on June 24, 2010, I timely mailed a motion for reconsideration to the court addressing the misunderstanding. Postal records and return mail from the court dated June 30, 2010, confirm receipt of that mailing. When I called the court to confirm filing, the court asked for a consideration of patience from me in receiving my stamped copy because of the 4th of July holiday and vacations. Ultimately, the motion was stamped received on July 30, 2010. The judge, not knowing the clerks had fumbled, and despite the fact that the defendant had defaulted a second time, ruled against the motion, stating that his belief that it was not filed in a timely manner. This guy believes things. Doesn't regard the truth, just believes things. Anyway, sorry for that transgression. This ruling was entered on August 27, 2010, which was the date assigned by the court for the hearing of motion. On April 15, 2011, a motion was filed which added additional information regarding the case. This motion gave a comprehensive appraisal of the 6 reasons why the motion regarding defendant's fraud upon the court should be granted. Any one of these reasons would be sufficient grounds to grant motion. As an aside, you only need one reason. I provided 6. Back to the book. Confusion or fault with one of the grounds Pro offered would not be an impediment to granting the motion because any of the 6 grounds were sufficient in and of themselves. Defendant, for the 3rd time, filed no response. The lawyer of record, who was also served again, confirmed by mail to the court that she was no longer representing the defendant. The requested May 20th, 2011 date for the court hearing on the April 15th motion was revised by the court to May 27th, 2011. That notice was also served upon the defendant, who again did not respond. I requested telephonic attendance to appear for the hearing set by the court on the date June 11, 2010, and requested the same for the May 27, 2011 hearing. In both cases, I received a letter from the court stating that since there was no opposition to the motion, the court would make its determination based on the papers submitted, and there would be no need for a court appearance by me on that date. The motion before the court was conclusively proved with concrete evidence. What could go wrong? During the week of June 6th to June 10th, 2011, I received a phone call from Judge Troiano's clerk, Crystal Burkus, who asked me questions which were irrelevant to the case or any ruling regarding it. This was well after my court date of May 27, 2011. Remember, I was waiting for a ruling that I believe was supposed to be delivered on May 27th. It was clear to me that the fact that there was no opposition to my motion meant nothing to Ms. Burkus. I had drafted a motion for a default judgment on May 19, 2011, but since I had received a letter acknowledging the default and stating the court would make its determination based on the papers submitted, I felt the motion would be redundant and a waste of the court's time and resources. I did not send the motion on May 29th because of that perception. But now, with the uncertainty brought on by my phone call with the court clerk, I decided to file the motion requesting entry of a judgment based on default. In fact, years of multiple defaults by the defendant. On June 10, 2011, that motion was received by the court, and on June 11th, I faxed a copy of it to Judge Troiano. The result was that a new court date of July 12th was assigned. As that date has come and gone, I have discovered that there is a statute in New Jersey. Orders are supposed to be handed down by judges within 10 days of decision. That's New Jersey Civil Part Court Rule. Remember, it's a civil court. New Jersey Civil Part Court Rule R442-1B. And I quote, "Absent good cause to the contrary, a written order shall be entered at the conclusion of each motion hearing." New Jersey Family Court Rule R55-4F. If the judge fails to sign and enter an order within the time prescribed by the two rules, it constitutes judicial misconduct. Example, lack of competency, lack of integrity, lack of impartiality, all violating the New Jersey Code of Judicial Conduct, Canons 1, 2, and 3. Violation of New Jersey Court Rule R214-1, removal of judges, citing New Jersey Statute NJS 2B2A1 to 2B2A11, and violations of the New Jersey Criminal Code NJSA 2C30-2, official misconduct, New Jersey SA 2C36, official deprivation of civil rights. Boom, there it is. NJSA 2C30-7, pattern of official misconduct. Since Judge Troiano showed that he did not respect that statute by failing to rule on the May 27, 2011 court date within the 10 days prescribed, and now has not ruled on the July 8, 2011 date, I assert that the motion is granted by default. It is clear that the defendant wants no part of this, which involved proving her fraud upon the court as stated in the motion, and gave her an opportunity to prove. It is also clear that the judge in this case has, for reasons unknown, become unwilling to acknowledge and rectify the damage of the egregious fraud perpetrated so many years ago. I do not demand to know why or why he has defaulted, but I will no longer accept that an unfavorable ruling is possible. I therefore respectfully request that my pro per attempt to right an egregious wrong be acknowledged and that my motion be granted. The defendant, my ex-wife, clearly no longer cares to defend the fraud. The court is supposed to be objective, but that is apparently not the case. I am not asking for anything that will cause damage to anyone. Only the return of my dignity and my right to live the remainder of my life as a working, tax-paying citizen. I do not know why my rights have been obstructed, but I ask that the obstruction be removed so that the motion is granted. Thank you, sincerely, Fred Satilli. Then, again in September, this is on September 19th, 2011, another letter to the ACJC, the Advisory Committee on Judicial Conduct. Dear Advisory Committee on Judicial Conduct, this letter is a follow-up letter sent to the ACJC on August 4, 2011. I have enclosed a copy. I stated at that time that Judge Troiano failed to obey the law by not making two rulings in my case in the time prescribed by law. I asserted at that time that I would no longer accept an unfavorable ruling from that judge because of that failure. Judge Troiano, in this case, has now filed such a ruling, a copy of which I have enclosed as Attachment A. Also on August 27, 2010, Judge Troiano filed a ruling, a copy of which I have also enclosed. The first reason for denial on the August 27, 2010 ruling of that motion was failure to file in a timely manner. In reality, that motion was filed in a timely manner, which is a fact that I have proved to the judge. I attach a copy of those documents to show timely filed hereto as attachment B. I find it ironic that a judge attempting to hold me, a pro per litigant, to a professional standard to which he does not hold himself. Judge Triano was 4 months late with one ruling and 2 months late with the second. The September 13th, 2011 order must be void for this reason. The law makes it very clear, again in relevant part, orders are supposed to be handed down by judges within 10 days of decision. New Jersey Civil Court Rule R 442-1B. Absent good cause to the contrary, a written order shall be entered at the conclusion of each motion hearing. New Jersey Family Court Rule R 5-4F. If the judge fails to sign and enter an order within the time prescribed by the two rules, it constitutes judicial misconduct. Examples: lack of competency, lack of integrity, lack of impartiality, all violating the New Jersey Code of Judicial Conduct's Canons 1, 2, and 3. Violations of New Jersey Rule of the Court R 214-1. Removal of judges citing New Jersey statutes SJSA 2B 2A-1 to 2B 2A-11. That's 11. It's 2. 2B 2A-1 through 2B 2A-11. And violations of the New Jersey Criminal Code, New Jersey SA 2C 30-2. Official misconduct, NJSA 2C 30-6. Official deprivation of civil rights, New Jersey SA 2C 30-7. Pattern of official misconduct. On the September 13, 2011 ruling, as item 1, the judge asserts that there were no new facts or law upon which to grant relief. I am enclosing the letter in memorandum filed in support of my most recent motion as attachment C, so that you can see the abundance of new basis upon which to grant my motion. The new material that the judge asserts is not new is highlighted in yellow. It is my guess that Judge Triano did not read this document. If he did not, he is blatantly derelict in his duty. It would then go to his lack of competency as a judge and public official who swore an oath to uphold, support, and defend the United States Constitution and New Jersey State Constitution. His incompetency and correlative lack of integrity and lack of impartiality would constitute a clear violation of the New Jersey Code of Judicial Conduct, Canon 3A1, lack of competency, and 3A4, lack of impartiality, as well as violation of Canons 1 and 2. If he did read it, he is not astute enough to be a judge. Therefore, Canons 3A1 would be implicated again. The statement that there was no difference is outrageous. I doubt that Judge Triano read this document. I pray that you do. Do not forget to read and regard the non-underlined part. Every word is important. Item number 2 on that ruling acknowledges default, but states that a default ruling is not granted because the underlying relief requested is not supported by the facts of law. This too is outrageous. The facts are clear and supported by irrefutable evidence. Also, the facts are supported by not only state and federal law, but New Jersey and United States Supreme Court precedents. Through the series of the defendant's multiple defaults, Judge Triano sent me several letters stating, please be advised that the court has not received any opposition to the motion scheduled for, example, July 8, 2011. Therefore, the court shall make its determination on the papers submitted, and there will be no need for a court appearance on that date. An order from the court shall be forwarded to you following the court's decision. I have enclosed a copy of such letter as Attachment D. The letter states that the decision will be based on the papers submitted, but it is not. This sadistic message of false hope is a flagrant violation of what every American knows, that being, when you are unopposed, you win. Judge Troiano clearly serves a master other than the law and the spirit of the law. I do not know what his problem is. He certainly does not elaborate it. I do not know that his bias in this case is caused... I do know that his bias in this case is causing undue harm to me. That would constitute violations of Canon 3A, 4, and 3A, 5, wherein a judge should be impartial and should not discriminate because of sex or marital status and refrain from manifesting by words or conduct bias or prejudice based upon sex, marital status at all. It is clear to me why both defendants in this case do not respond to the very serious charges of extrinsic fraud upon the court. They must be confident that they have the protection of an advocate in that court. It appears obvious to me that they do. Judge Troiano, in fact, is clearly in violation of the Code of Judicial Conduct. The defendants clearly misled Judge Convery in 1999 and 1998 and 99. When they got was essentially an ex parte order by default, and now Judge Troiano is clearly protecting them. The simple fact that the impossible support order that was responsible for this problem was computed with a figure provided by the defendants that was nearly 3 times my earnings is enough to constitute the extrinsic fraud that voids the original ruling ab initio. I have proved my case. I have done so. Relief in the form of a proper court ruling is my right. Now that Judge Troiano has violated that right and my trust, the onus is on the court to police itself. This must be done to protect the rights of a defrauded citizen, uphold the United States and New Jersey constitutions that this judge swore to uphold, defend, and support, and to restore the integrity of the court. Thank you. Sincerely, Fred Satilli. That's the end of the chapter, and I sincerely hope that it speaks for itself.